today on this Tuesday afternoon for our next segment in our summer webinar series. Today, we are going to discuss managing difficult employee terminations and discipline situations and share some best practices to follow as the employer. If you've joined us in the past, you know I'm Sophie Dietrich, the HR professional for the Compliance Center team here at Wagner, Falconer, and Judd. Our team is dedicated to supporting your business as you navigate any and all human resource and employment law situations, and we're very happy to have you with us today. So, some quick housekeeping items before we get started. Please send your questions via the chat option at the bottom of your window. We should have time for some questions at the end of the presentation, so send them our way. Also, so you are aware, the webinar is being recorded to share with those who can't attend live with us. So, with those items covered, let me introduce you to our presenter, Janelle Stanton. As many of you know by now, Janelle is a senior associate with the employment law team here at Wagner, Falconer, and Judd. She brings over 9 years of employment law and business litigation experience to the table, and she dedicates much of her practice to teaching business leaders on all things HR and employment law, like we're doing in this summer series. You've heard me say before, you'll hear me say again, she's our favorite thought leader to have around, so we're always excited to have her share with us. So with that, thank you again, everybody, for joining us, and I'll hand things over to Janelle.
All right, awesome. Thank you, Sophie. And I'll just echo what Sophie said. Welcome. We're excited to have you with us today. We are going to talk about managing difficult termination situations. And this month, I thought we would do something a little more fun. So we're going to try playing a game called Stump the Lawyer. And so if any of you, I've got a bunch of content to go through, but at the end, what I'd like to do is go through some real live, not maybe going on right now situation where you need legal advice, but terminations, difficult terminations you've heard of before, issues you've faced in the past, things that you're like, whoa, this would be a really hard one. This one could potentially stump Janelle. Termination situations. If you could go ahead and toss those in the chat. So, come up, you give us 2-3 sentences about the situation and, what the question would be. So can I terminate? What's the best next step? Just go ahead and throw those in the chat and we'll run through those examples at the end and we'll see if you guys can stump me. So I think it can be done. I have hypotheticals built in, but I think it'd be more fun if you guys participated and had some examples. So think on it throughout, type that in. I'm going to go forward with the presentation and then we'll do those, that kind of stump the lawyer piece at the end. So proper terminations are really, really important for companies. They can save you a lot of money. They can save you a lot of hassle. And one of the things, obviously we're always talking about lawsuits and things like that, but on the front end, it actually costs quite a lot of money to hire and train new people. So you're going to lose productivity, opportunity costs, things like that, if you have to terminate an employee that, you brought on, but wasn't able to do the job, didn't perform to the standards that you had expected. I'm going to botch this statistic, so I'm not even going to throw out a real number, but it's way, way, way more expensive to recruit, hire, onboard, train a new employee than it is to go through a termination. Of course, that is unless you're facing a employment-related lawsuit, but it costs money to hire and train. It also costs money to fire people incorrectly. So you bring on the wrong person or you bring somebody on who originally was a stellar performer and now they're underperforming. If you fire that person incorrectly, you're going to find yourself in a position of defending a lawsuit. It's hassle. It's bad for morale. It's bad for publicity. The EEOC, they put out press releases and they name the companies in these press releases where they've either filed suit or brought charges on behalf of employees. So if a company, you're trying to recruit an employee and an employee goes out to the Google machine and they look up your company name and they see that you've recently settled some lawsuits, that can be really difficult to overcome in the court of public opinion. So it gets very expensive to be handling terminations improperly. So really, really important that we think about all of what I'm going to cover here first before we get to that point where we're ready to terminate somebody. So
Hey, Janelle, can I jump in? I
yeah, of course.
don't I don't think we see your screens advancing if you have started moving along the slides yet.
I have. All right.
Might need
Really?
to, yeah, swap, maybe just swap your screen share. Try once more.
Okay.
I just saw it move now, but it's not in presenter mode.
Okie doke. Let me double check. Start sharing the screen. Entire screen. I'll just do entire screen and see if that helps.
There we go.
All right, are we good? Do we got it?
I think we're good. Thank you so much.
Yeah, thanks for letting me know. All right, you didn't miss a whole lot with this particular slide, and we can make the slides available to everybody as well. Sorry about that. So one of the things that we hear all the time from our clients is, well, this is an at-will employee and that's not, we can't get sued because they're at will. And the unfortunate answer to that is, while at will employment means that you can terminate an employee for any reason or no good reason or a really dumb reason, it doesn't mean that you can't get sued for that. So at will employment really is only protecting you from a breach of contract suit. If you have a contract with an employee where you're guaranteeing a period of employment for 3 years and you terminate them, you can be subject to a breach of contract suit. But at will employment doesn't do anything to prevent you from getting sued. The other thing I wanted to mention is EPLI coverage, Employment Practices Liability Insurance. Many of you already have EPLI coverage, and I hear clients say, well, this might be an icky kind of termination, but it's okay, we have EPLI, which is great. I love that. That's wonderful that you have that, but there's a few problems with that idea. So first of all, you have a retention retainer. So it's not free to engage the attorney to represent you in a lawsuit. So some of those engagement retainers might be $5,000. Some of them might be $50,000. Also, now you have a claim, and once you're filing claims, your carrier might be like, might be somebody we want to drop. But also, I think employers are forgetting about the amount of time that they personally are going to have to invest in a lawsuit. So if your company gets sued, there's going to be an answer process. So we have to put an answer in place for you. So we're going to have you go through all of the allegations of the complaint line by line and tell us whether we can admit, deny, or don't have enough information to admit or deny. So that's just step one. Then you have to tell us who should we say has knowledge of this matter in the initial disclosures. Then we have to do potentially early mediation or mediation later on. Then we have to do discovery. Discovery is incredibly time consuming. I am representing a company right now in a litigation matter, and he's probably spent almost 40 hours pulling text strings and Teams message strings for us in a way that we can produce that to the other side. So that's not even getting to trial. If we get to trial, there's depositions and then trial. And so thinking about, EPLI is wonderful. It provides you, it pays for your defense for most issues. A lot of times, wage and hour things are accepted from EPLI coverage, but it's great. It's just there are some downsides to that as well. And the other exceptions, so the main exceptions to at-will employment, it's not going to protect you from any of these claims. So you can fire somebody for any reason at all under the sun except for discriminatory reasons. So you can't fire somebody because of their race, ethnicity, national origin, creed, religion, sex, gender, hairstyle, any number of protected classes that are protected by the law in the state where you have employees working. Minnesota, there's the Title VII that has the federally protected classes, but then Minnesota has the Minnesota Human Rights Act, which has even more protected classes. Other states have other protected class statuses, so we can't terminate somebody for those reasons. Retaliation whistleblower. This is a huge area right now that I would say that if you talk to anybody on my team, almost every charge that we're looking at right now has a retaliation component where the employee is alleging that they complained about sexual harassment. They talked to HR didn't do anything about it, and the harassment continued, and then they were fired for that, for complaining about that. Defamation, it's not going to protect you from any of those claims, or promissory estoppel. Promissory estoppel is kind of it's not a super easy claim for somebody to bring, but they could try to say that you had an offer, you made an offer of employment, and based on that offer of employment, the employee quit their job, they moved across country, bringing their family with them, incurring massive costs, only to get here and have you be like, yeah, you're not the right fit for us. So there are some claims that you can still be subject to. There's also keeping in mind that there are other employment laws too that you need to be complying with. FMLA and ADA and other protected leave laws, most of them have a reinstatement right built right into them. So the FMLA guarantees reinstatement to an equal or better position with similar terms and conditions and benefits of employment. ADA is very similar. Paid sick leave law. So Minnesota's sick leave law has a reinstatement component as well. So if you go ahead and terminate an employee who is just returning from FMLA, this is a legally fraught time. And so just be aware that these laws all do have some element of reinstatement and an obligation that the employer restore the employee's employment. Now, there are exceptions to this, and we'll talk about those later on in the presentation, but just something to be aware of. Now, I would say that this slide is maybe feels a little counterintuitive, but as soon as you hire somebody, you really should be laying that foundation for the potential of a termination later on. And it's, like I said, counterintuitive because we never hire somebody with the vision of firing them. That's certainly not the case. But there are, throughout the employment relationship, there are steps that you can take to make sure that if you do ever have to terminate somebody, you have good, solid documentation and legal basis for that. So, one of the first steps is the drafting of the job description. So drafting a job description is very, very important. I'm going to come back to this slide. I've got a little example here. Let's talk about the importance of job description. So large legal publishing firm hires account managers to maintain the company's client relationships. Sounds great. The account manager job description states the job duties as follows: take inquiries and requests from clients and address their needs, stay on top of accounts, making sure they're receiving services that are within their budget and meeting their needs, meet regularly with other members of the team to discuss progress and find new ways to improve business, generate progress reports, and identify opportunities to upsell and cross-sell. Sounds pretty great, right? So lately, several clients have called to complain that David, an account manager, has not been in contact with them for months and does not respond to emails or voicemails. Upon investigation, they've determined that David only communicates with his customers around the time of renewal and that he allows other team members to handle customer complaints. When HR confronts David, David responds that it's not his job. Sound familiar? That customer service and technical support are responsible for handling customer complaints, and that troubleshooting is beneath him. Hate that, but all right, that's David's position. So since David's not fulfilling the duties of his job description, can HR terminate him right away? Well, let's go back and make sure that we're, looking at this. So take inquiries and requests from clients and address their needs. I mean, it's pretty broadly stated. So I would say that the company is in pretty good standing to say that part of David's job is addressing customer needs and complaints as they come up. If we change the facts just slightly and we say several clients are calling to complain, they do this investigation, and when they confront David says that excessive client contact exacerbates his anxiety, that customer service and technical support should be responsible for handling his customers' complaints as a reasonable accommodation. Well, David's still not fulfilling the duties of his job, but can we go ahead and just terminate David right away? Probably not. We need to see and go through the ADA interactive process to see whether we can accommodate him, whether this is a reasonable accommodation. Can he still perform the functions of his job if customer service and tech support are handling these things? I don't know the answer to that question, but you can see how a job description is really, really important and can help lay that foundation for terminations early on. So if he's not doing part of what his job description requires, then he's not fulfilling the functions of that job. The application process is another place where you are potentially laying the foundation for a termination. So in the application, has the employee lied about years of experience? We've seen this before. We've counseled clients where applicants have lied about their experience. They've come onto the job only then to later find out that they're actually not as experienced as they said they were, and or they just outright lied on the application. So that again makes for a good defensible termination in that context. Same with the interview process and any pre-employment testing, reference checks. All of these elements of that early onboarding process can help you lay the foundation for a good, solid termination later on. So we want to keep it going. Obviously, once the employee is onboarded and they're working in their position, it's really important that you continue to think about what might come down the road. So make sure that the expectations of that employee are well defined. If the expectations for the employee are very nebulous, you don't have specific KPIs or targets or goals, how do you measure success? How do you conduct a performance review of that employee when there is no defined expectation? So then how do you say they're not meeting the expectations of their job? So it's really important as managers and leaders in your company to make sure that you have goals, metrics that you can measure to those goals, that you are doing performance evaluations at least quarterly. I don't like once annual performance reviews because I don't think you're too late then. You need to do these performance appraisals along the way. That will help ensure that employees understand what exactly is expected of them, and so that if you do quarterly performance reviews and they're below expectations a few quarters in a row, if you then have to terminate that person, they're going to say, oh yeah, I knew this was coming. I know this is just not a great fit for me. So defined expectations is critically important to making sure that if you do need to terminate that employee down the road, it's very clear why. They weren't meeting their KPIs. They weren't making the metrics that you had set forth. Discipline policies, make sure that the big thing about discipline policies is making sure that they are evenly applied. So if you discipline one employee for missing their sales goal for 3 months in a row, but then you give another employee a pass and they've been missing their sales goal too, but you happen to know their dad, or you really like that person because they were a personality hire, something like that. um, that unequal application of your policies and the expectations can lead to claims of discrimination. Somebody's going to say, well, wait a minute, I know, I wasn't meeting my goals, but I also know that Sally over there wasn't meeting her goals either, but she still gets to stay employed here. So there's, and then perception is reality. So then it's always going to come down to, well, I was treated differently from Sally because of my gender, my race, my religion, what have you. So being very consistent with how you enforce your discipline policy, how you're documenting any violations or PIPs. We're going to talk extensively through this presentation about the extreme importance of documentation. As it relates to performance, good, solid documentation is critically important. And that documentation should be created contemporaneously with the conversations that you're having with your employees. Let me give you an example. I talk to clients all the time who say, well, this person's not really been performing, but we don't really have any documentation because we've just done like this verbal coaching and stuff. And I'm like, stop right there. Verbal coaching. That's fantastic. You walk down to somebody's office, you have a conversation with them. You say, you're not doing this, and this correctly, and we need you to improve. Go back to your office and write that out. You don't have to give it to the employee, but you say, on what is it? July 30th, 2024. I had a conversation with Sally about missing her sales goals. And she's going to try to make more discovery phone calls, and is going to 5 times a week check in with current clients for upsell opportunities, whatever that happens to be. You can document that verbal coaching, because that's usually where discipline starts. Is you have a little conversation with somebody, say, oh, be careful of your tone on the phone, and the client didn't really appreciate that, or whatever. You can still write that down. And so then when you're like, gosh, Sally's just been a real issue, what's going on? You can go back to your notes and be like, oh yeah, I've had to coach her 4 different times and it just doesn't seem like it's resolving itself. Well, that's where you do a written warning potentially, or a PIP, performance improvement plan. You are then going to have great documentation to back up and justify that PIP, because you've had all these verbal coaching sessions that you can note, one from July, one from September, one from January, one from February, that you can put in the PIP with very clear expectations for how that employee can improve over time, with some really clear defined expectations. Maybe you need some new metrics. Maybe you need some new KPIs that you can think through, SMART goals. If we want to use some nice corporate lingo, SMART goals. You're, again, laying that foundation, because if you have all these great notes about an employee over time, this just helps you later on. If you do think you need to make the decision to terminate, it becomes very, very clear, and it's justified. Because if you call me after you terminate an employee and you say, oh, we terminated this employee and now we got a lawyer breathing down our neck, first thing I'm going to ask for is your documentation. It doesn't need to be fancy. I have represented clients where their documentation was on like those Trout Unlimited free notepads that you get from Trout Unlimited. It's dated, it's signed. I don't care what it looks like, but that documentation needs to be there. What I personally do is I manage a team of, I don't know, 30 or so people. I have a Word document for every single person on my team. And if they, make an error, they're late, they do something that I don't like, I write it down with the date. If they do something awesome, they volunteer for a project, they help out a team member when we're short staffed, they stayed late for something. I write that down because our memories are super fallible. And so keeping those notes as you go is really important. And like I said, I could care less what the format is, but keep the notes. Along those lines, investigations. If there's an allegation of something, somebody says, that Sally has sexually harassed me, or I'm reporting an unsafe workplace condition, or I have been unfairly denied a promotion. It is incredibly important that an investigation be completed. That is that's an area that a lot of employers are missing, is doing that investigation. They hear the allegation, they make up their mind about the allegation without doing the investigation. They determine that the allegation's probably unfounded, and then they move on. Well, if you don't do that investigation when complaints are raised, that is one of the elements that can help an employee bring, for example, a hostile work environment claim. Because to bring a hostile work environment claim, there needs to be hostility based on protected class status that the employer knew about and did nothing about. So if you're doing an investigation, you're asking those questions and getting curious, you can, again, that can help you make those decisions for termination. So if you decide, you know what, after doing this investigation, what I previously thought was wrong, and it looks like Sally's complaint, Sally is actually sexually harassing people, and then I can go through and give the discipline that's appropriate in that circumstance. So we want to be thinking about, in our investigation process, never investigate with the thought that the alleged perpetrator has done what they're alleged to have done. Have a curious mind, but they're, again, doing that investigation, making those credibility determinations, and ultimately having a great investigation file and record can set the stage for a solid, smooth termination later on as well. You also need to think about the termination meeting. I think that a lot of people, in haste or in a just pissed off mood or whatever, they march right down to somebody's office and they, get out of here, you're fired. Now there could be times when that reaction is totally warranted, right? There's a violent situation happening. Somebody's threatening somebody's, there could be times when that's a reasonable approach, but that's most likely not going to be the case. You want to think through the termination meeting. How are you going to do this? Who is going to be there? I always recommend having a third person in the room with you so that you can help try to avoid that he said, she said situation. What are you going to say? It's at will employment, but maybe we want to just say, look, we're going to let you go today because you've not met your sales goal 3 months in a row, and that's our requirement. And then that's it. And then you talk about final paychecks and COBRA and all that lovely stuff. You got to think about what you're going to say, because you don't want to say the wrong thing. You don't want to get in there and, oh, we just love you so much, I'm so sorry, corporate's making me do it, blah, blah. You don't want to do that. That's wishy-washy. That makes it seem like maybe you're covering up an improper termination reason by apologizing, saying they're great. Well, if I'm so great, why are you firing me? And so have what you're going to say prepared. If you can have the final paycheck, wonderful. If you can have the COBRA documentation and everything ready for that meeting, that is kind of the gold standard. The last thing I want to talk about is separation agreements. So not everybody wants to give an employee that they're terminating a severance. And I understand that. But if you're in a situation where maybe there's some legal complexity to this, maybe they just had a baby, maybe they, just recently were on social media complaining about the wages that your company pays, or they've recently just got done, through a sexual harassment investigation or something like that. If there is potential for legal trouble, it may be something you want to consider is offering a severance, either a lump sum payment, payment over a several month period, paying for COBRA, outplacement services, things like that, for a period of time in exchange for the employee signing a separation and release of claims agreement. Never, ever give an employee that's you're terminating something that they weren't otherwise legally entitled to without having them sign that separation and release of claims agreement. That separation agreement is the document that says, in exchange for this nice thing that I don't have to do for you, but I'm doing, you are agreeing not to sue us. I have also, again, had companies where they have, oh, we feel so bad. We're just going to pay out his PTO. He's not technically entitled to it. We don't pay out PTO. We're just going to do it out of the goodness of our hearts and go, he'll just go on his merry way, which is great. Until that person then comes back and files a charge and then a lawsuit. I understand the drive and desire to, do these types of, benevolent things, but you have to get a separation agreement signed if you're going to give the employee something that they're not otherwise entitled to. I covered most of this. So I talked about defined expectations, following your own policies, don't make things up. I mean, that's just, goes without saying. One thing that I've seen a couple of times in lawsuits recently is PIPs that are impossible, like a PIP that nobody could ever possibly achieve, or a PIP that's only just one piece of paper, but they're destined to fail it, and they just use it as a final written warning. A PIP that is unachievable can go to pretext and can cause issues if it's something that you're trying to rely on as the basis for your termination. So make sure that the PIP, the point of a PIP is to actually get the employee to improve. If you don't think that there's any ability to improve, or you're just done and fed up, skip the PIP. I wouldn't do it because it really is meant to be something that improves performance. So it shouldn't be like a sham PIP. That's not going to help anything. Okay, I got an example here. This is about company policies. So a while back, we talked about developing and applying company policies consistently. And I cannot tell you again how many times I have reviewed handbooks that have this. Step 1, counseling and verbal warning. Step 2, written warning. Step 3, suspension and final written warning. Step 4, termination of employment. And if you're sitting there going, ooh, geez, that kind of sounds a lot like our discipline policy, you might want to talk to us about that, because let's say we've got Hollywood star Lanes here who prohibits employees from bowling while on the clock, but management largely overlooks this. Employees often bowl a few frames when it's slow. So we've got Walter, a vet, couple protected class statuses there. He's working for the bowling alley, and immediately it's clear Walter is not going to get along with his boss, Donnie. Donnie is a pacifist, and he disdains Walter's previous military service. Donnie wants Walter fired After seeing Walter bowling while on shift, Donnie calls Walter into his office, fires him, citing the company's on-shift bowling prohibition. Walter protests. He says other people do this too, but Donnie points to the policy and stands firm in his decision to terminate. What issues? Well, now it looks like, well, first of all, you're not following your progressive discipline policy. Other employees are bowling when it's quiet and Walter's doing the same. It kind of looks like maybe Walter's being fired because he's a 55-year-old Vietnam War vet. That's certainly the claim that Walter's likely to make. And so applying your policies consistently, avoid overly prescriptive discipline policies where you get, you know, three bites of the apple and then you're out. Like, you want to be able to apply the appropriate termination to the situation depending on the factors at play. So you want to be able to discipline somebody. You terminate somebody for one infraction if it's a very serious infraction. You also want the ability to skip steps. So maybe you do a verbal coaching the first time, but the next issue or situation is so egregious, then you jump to termination. The point is your company should keep avoid those progressive discipline policies. Make sure that you have policies that give the company maximum amount of latitude. Be equal, even-handed. Don't, discipline one employee harshly, giving others a pass, things like that. A couple of other things, and then we'll get into our examples. And so, here we're getting down to crunch time. So if you've got a great sample or story that you want me to cover and you want to try to stump me, now's a great time to get that put in there. We talked about this a lot, but papering the file. Documentation is so important. I would say that most suits that arise out of terminations are going to live and die based on what is in the file. If you tell me, well, Janelle, we had economic downturn and we could not afford to continue to employ Sally, and so we let Sally go, but Sally just got back from FMLA leave. Well, what kind of documentation do we have to say that we had this conversation before she was set to return? We have, financial documents to show the downturn that we're facing in Sally's department, things like that. And the lawyer's going to always ask to see that documentation first. So not only can it help reduce lawsuits, because different times when I'm negotiating with an attorney on the other side, I say, your claim has no basis. And by the way, I have emails that show this decision to terminate the employee was made a month before they returned from leave, for example. So that can scare off an attorney and prevent a lawsuit full stop anyway. But if that doesn't work, it also creates great evidence, because if we need to if we need to do some discovery, or we are going to go into trial and we've got great documentation that justifies and shows this economic downturn that led to the reduction in force or layoff, that's good evidence. That can help you win a lawsuit right there. If you have no evidence and you're solely relying on HR's memory and testimony, memories are fallible. We know that. And testimony, witnesses are humans. We're humans. We might forget details or misspeak, or lawyers have a knack for getting people confused and saying things that they maybe don't mean. And that shoots the credibility of that particular witness. When you have documentary evidence behind that, it can help win that lawsuit, because you're not just relying on testimony. You're actually looking at the emails, the text messages, what other documentation there is. Like I said, make sure you document contemporaneously. You don't want to have to go back and piece together documentation. Now, I've had clients do it, don't backdate it, but if you are sitting there thinking, oh, God, I got a terrible employee and I've not been documenting it and I really should have been doing that, it's okay. Take a breath, open up a Word document and go back through your emails. See if you can recreate what's been going on with this particular employee. Maybe you can look at your calendar and you can see that you had a meeting with that employee back in June on your calendar. So that refreshes your memory. Oh, yeah, I talked to Sally about this in June. You can write that down. Don't, like I said, do not backdate things. That is disingenuous. That's a lie. So don't do that. But you can still recreate that documentation and make sure you're sticking to the facts, providing enough details, and that all of that. So again, the formatting of it matters zero. It just matters that it's there. A couple of other things, and then we'll get into our situations. Have a face-to-face termination meeting if possible. Obviously, we're still working in a time, where lots of people are remote. So if you have to fire somebody over Zoom, the phone, what have you, that's fine. I wouldn't probably fire somebody over an email. It's got a lot of terminating by post-it note vibes to me. So do face-to-face if possible. Be very, very careful what you say. Okay. Because what you say can have a huge impact. Maybe you have all the reason in the world to terminate an employee, but one little slip of the tongue, like, I really hope you get some help. You're nuts. You got something going on. Ooh, okay. All of a sudden, it looks like maybe you're actually terminating somebody who's got a mental health condition that needs potentially an accommodation and not to be fired. Be very careful. Be very planful for these meetings and have an idea of what you're going to say. And if you're nervous about it, just read it. You don't have to memorize it. It's not great to have to read it, but if you're nervous and you don't want to mess it up, you can write yourself a script. That's just fine. Like I said, have another person present. Don't apologize. I understand we are all mostly, I shouldn't say all, some of you might not be, but we're mostly good, Midwestern, lovely people. And it is just against our nature to be tough on somebody, to fire somebody, to say, we're letting you go today. That's hard. So what we want to do is say, I'm so sorry, but we're going to be letting you go today. Just work on getting that out of there. Say, we've had a couple of discussions already. I think you know that you're not meeting the metrics we expect of you. So we're going to be letting you go today. And take a breath. And then start going into pay, COBRA, all of the other separation agreement. Give them the separation agreement. Have all of those other pieces ready. Talk about how you're going to pack up their office or workspace. Give them the option to either pack it up while you stand there and watch them, or tell them they can go and you'll pack it up and messenger it to them. So think about how you do this. I like KISS, keep it simple, stupid, but keep it simple. Can't go wrong. You really can't. So, all right, Sophie, before I go into my own made up scenarios, did we get any bites on our Stump the Lawyer game?
Hi, yes, we did. We got three. So I will start with one of them. So a newly hired employee has not responded to many of the requests for completing onboarding and assigned work tasks. The employee leaves after working for 2 weeks to go to his parents out of the country as one of them is ill. He has come back, but is still not communicating well or completing his work. He has been spoken to about these issues. He says he thinks he's going to take off several months to go take care of his parents. Would you say termination, or would you say the company would be at risk?
Great question. So, if we start thinking about what are the laws that might apply here? So, first of all, we can immediately knock the FMLA out because he's a brand new employee. So there's no risk with FMLA. Is there any risk with the ADA, the Americans with Disabilities Act? No, There's no risk with the ADA because the ADA only protects the employee, it only requires accommodations of the employee's own disability. Is there a potential that termination could violate Minnesota sick and safe time law? Well, potentially he might, depending on whether your company front loads time or does an accrual method. If you do the accrual method, he maybe only has 1 or 2 hours of paid sick leave to use. So certainly being gone for weeks or months is not going to be covered. Then we go to, is there any discrimination? I mean, he's not working, he's not doing the job. So I don't see any risk. He's not saying, well, he's not saying, that he's not giving any reason for um, the need for leave that's based on, protected class status. He's not, there's no whistleblower issues, there's no retaliation issues. I mean, I think that this is probably a pretty good case for termination. I'm not seeing a ton of red flags. You could, you know, do the sort of one last chance sort of thing, but I don't know that I would do that here. And so maybe this is something where you're like, this isn't working out. We're going to give you a week of pay, sign the separation agreement. Let's go our ways. It's just, this isn't working. But I think that the risk on that one is relatively low.
And Janelle, a clarifying comment came in too from the submitter. They said the employee is a remote worker.
Yeah, that doesn't change anything for me.
Okay, great.
Yeah, I think
Thank
it's the
you.
same analysis.
Great. Okay. And then we have two more.
Okay.
So we have an employee who has used all of their available resources, so FMLA, LOA, PTO, ESST, but has continued to call in sick or leave early from work. They were not able to qualify or complete the ADA process because an accommodation was not found to help them meet the basic functions of the job. And this is a past tense, so they ended up using attendance as the justification to terminate the employee because attendance was the essential function of the job.
Mm-hmm. Yeah, I mean, I think that is assuming that that full ADA process was gone through. So you got the medical documentation, you looked at what accommodations might allow that person to have good attendance, and you tried different things, and ultimately at the end there were no accommodations. Attendance as a essential function of the job is a legitimate reason to terminate somebody. It has to be, it can't be contrived. It can't be that, well, technically this person could do their job at home. It's just our preference that they be in the office every day. And so if they're not in the office every day and they want to work from home, it can't be contrived. But obviously there are lots and lots of jobs out there where attendance is super key because you staff a certain kind of way. And if, as long as the justification um, holds water, it's reasonable. I think that is probably a lower risk termination situation as well. Again, presuming that whole ADA process was gone through.
Thank you so much. And we have one more.
Okay.
So there is an employee with consistent attendance and communication issues. The employee was hired in April and they've already been absent for 25% of their time here. They have gone through progressive discipline, coaching, verbal warnings, and a written warning about this issue. But recently, the employee provided a doctor's note to excuse their absences. The employee does not qualify for FMLA, but this could be an ADA issue. Um,
Mm-hmm.
they are having issues with the work because it is the job the employee is supposed to be doing is very critical. They are in accounts receivable, so they're doing, payroll and business expenses, all of that. They
Mhm.
have started a PIP process for them, but they believe due to the seriousness of the situation, they need to find another solution.
Mhm.
They're wondering if there's anything wrong with moving the employee to a different department or moving them to part time. They say their PEO will not budge on this issue.
Oh, okay. So moving a job transfer is an accommodation of last resort. So if there's no way to accommodate this employee, I'd be curious to know. I'm probably not going to be able to give you as full of a analysis on this one because I think that I need to know a lot more about the condition, why, what the doctor's note is about. But I do think an accommodation of last resort is a job transfer. So if you have, and if there's another position that the employee is qualified to perform that's open, that may be the best solution. But that would be something you'd want to determine in talking with the employee and say, look, we're having a hard time here finding an accommodation that'll work given that you're in this really critical accounts receivable job. What do you think about moving to, I don't know, inventory, where, you can, it's a little more flexible schedule and it's part-time, but it's something that we think you're qualified to do. I think that that's a reasonable next step. I would be interested to, of course, learn more about this because that it's possible that that is maybe not fair depending on what other steps you've been through, but a transfer can be an accommodation of last resort for sure.
Well, thank you. So
Okay.
that is all of our questions for now. But if any of our attendees have other ones they want to bring up, you can always submit a ticket to us. We are here, and we can talk through them individually too.
Yeah, we've got some time. So I'll just run through my pre-made up scenarios. So, and if something else comes in, Sophie, feel free to jump in. The hostile employee. So we've got John. He's exhibited some volatile behavior in the workplace, including angry outbursts, confrontation with colleagues. His behavior has been reported multiple times. He's received verbal warnings. There is some speculation that John's behavior might be related to an undisclosed disability, but no formal documentation has been provided, and John has never asked for an accommodation. What should the company do here to mitigate risks? So this would be a good place to ensure that your company policies on behavior and conduct are really clear, communicated, that you're consistently enforcing them. Documentation is also important, keeping records of all the incidents, the steps that were taken to address them, including the warnings and investigations. I think doing an investigation here is wise. Talk to any witnesses of his behavior. Talk to any additional witnesses that those witnesses identify. And this might not be a bad time to consult legal guidance as well. To talk to an attorney, see if there's any ADA issues. I suspect there's not. So to be protected under the ADA, the employee needs to communicate about that disability if it's not obvious, and they need to ask for some kind of accommodation, which hasn't happened here. So, you sit down with John and you say, John, look, you have done A, B, C, and D, and that is a violation of this policy. And we've tried to talk to you about this. We've written you up. Your behavior is not changing. We're going to need to let you go. And if he says, I know, I've been really struggling lately. I'm getting a divorce. I'm depressed. I've got anxiety. I'm seeing a counselor. Maybe that's where you pump the brakes, but maybe not. A lot of this is going to also depend on the company's risk tolerance as well. Sometimes terminating an employee where there is a level of risk involved is worth it. Now, depending on what kind of threats John is engaging in, it might be a safety issue. It might depend on the environment that John is working in. If he is a lot of times working late shifts where there's not a lot of managers around, maybe that's a higher risk situation, and you're going to be more quick to jump to a termination. Might also be a situation where a referral to an EAP or a separation agreement might make good sense. Downsizing an employee on leave. So Sarah, she's a valued employee. She's been with the company for 5 years. She very recently returned from FMLA, where she took time off to care for a serious medical condition. However, due to budget cuts and organizational restructuring, her position is being eliminated. The decision is purely financial, but the company is concerned about the risk of a retaliation lawsuit. What should the company do to mitigate risk? Again, documentation. Just like document, paper the file. Keep detailed records of those economic factors that necessitate the downsizing. And be specific about why Sarah's position was selected, especially if the only person you're downsizing is Sarah's position. Maybe her productivity is much worse, or she's much more highly paid, or there's other good business related reasons that have nothing to do with her FMLA as being the reason that Sarah's position was selected. Obviously, much better if there are others in Sarah's same position that are chosen, but you'd want to be specific about why her. Transparent communication is also really critical here, because she's going to say, I was downsized and that is BS. And it's actually because I took FMLA. And so being sure to share maybe some of the details about the economic factors with Sarah might be a wise choice. Again, consider a severance and have, a separation and release of claims agreement ready for her to sign. Team communication is also really important when you're going through a downsizing. So the remaining team should be informed about the downsizing, make sure that they understand, and have a focus on the future plans and stability of the company. But it's important to remember that even though their FMLA does have that reinstatement right provision in it, employees who go out on FMLA are not given more rights than others who didn't use FMLA. So if their position would have been eliminated, regardless of whether they went on leave, then this is not going to protect them, and it's not going to require that they be reinstated either. So, Sophie, has any more questions come in?
Yes, one more.
Okay.
Is an anger issue caused by a brain injury protected under the ADA?
Potentially. So that's going to depend a ton on the circumstances. So let's say you have somebody who has we can go back to Walter, Hollywood Star Lanes. Walter's got anger issues because he had suffered a traumatic brain injury or something. But it doesn't really present. And if he is given breaks throughout the day where he can take some quiet time and have some rest, he doesn't have those angry outbursts in the workplace. Yeah, that might be something that you have to accommodate. Now, if Walter has a TBI and breaks don't help and medication doesn't seem to be helping, and he is working in a plant that has tons of anhydrous ammonia and he could blow up the entire town with it, and he's made some threats. I mean, maybe in that situation, there's a direct threat and, argument to say, we can't accommodate Walter. I mean, we feel really bad, but it's too much of a safety risk for him to be here. It's still going to be a risk. He's still protected by the ADA, but it might be an undue burden and potentially a direct threat to the health and safety of himself or others to allow him to continue working there. So the context really matters with that question.
Great. Thank you, Janelle. That is all we have for right now.
All right. Well, thank you. Thank you so much for attending. There were a couple of other examples in here, but we'll make sure you guys get the slide deck so you can look through those. If you want more information, feel free to reach out to Chris. He can get you hooked up with us, or if you're already signed up for our service with the Compliance Center, feel free to go in and open a ticket to discuss any of the issues that were brought up today or anything that was surfaced when you were listening to me chat. Thanks for attending. Take care, everybody.